Hi, my name is Michaela Posner. I'm an associate in the Los Angeles office of Weinberg, Roger, and Rosenfeld, and I'd like to take a moment to discuss a decision from the Public Employment Relations Board, or PERB, that was issued on about February 27th, 2024 of this year. It deals with the union's right to information from the employer through information requests. Unions in both the private and public sectors have the right to information that they need in order to represent their members. This can include information necessary to bargain a collective bargaining agreement so that they can craft their proposals or their counter proposals, figure out how to respond to a proposal from management. Unions also have a right to information in order to file and process grievances, which is the mechanism that unions use to enforce their collective bargaining agreements. Unions have a greater right of access to information than the general public. You've probably heard of a FOIA or a SIPR request, which is a request for information from the federal government under the Freedom of Information Act, or the state government or a public entity in California under the California Public Records Act. Unions are entitled to all of that information, plus additional information that is not available to the public. This includes personal information about workers represented by the union, including personal phone numbers, emails, mailing addresses, and residential addresses. In the private sector, the National Labor Relations Board has held for several decades that unions also have the right to demographic information about their bargaining unit. So a union has the right to know the gender and the ethnicity of every member of the bargaining unit, of every worker that they represent. Under federal law, most employers are obligated to collect this information. This information needs to be reported to the federal government in EEO reports. So employers already have this race and gender information that they report in an aggregate form to the federal government. For instance, employers will not report that Susie Q identifies as a female, but they will state that 52% of the workforce identifies as female, and so forth and so on. So the private sector has had that right to that information for several decades, but there was no decision in the public sector stating that unions have a right to that same information. And so that takes us to the case that I want to take a moment to discuss today. This case started in 2019 when the city and county of San Francisco shared the results of a study that found that Black employees were released from probation or fired before or on the 90th day of employment, or had their probationary period extended at a disproportionately greater rate than other employees. Based on this report, the union, SEIU Local 1021, filed a class action grievance alleging racial discrimination in the workplace. The collective bargaining agreement that SEIU Local 1021 negotiated with the city and county of San Francisco had a provision in it that prohibits discrimination and harassment based on protected characteristics such as race, gender, ethnicity, national origin, religion, and other statuses that are protected by state and federal civil rights laws. And it's actually pretty common for union contracts to contain an anti-discrimination clause like this, in order for workers to have another avenue to challenge discrimination and harassment and retaliation in the workplace. So the union filed a grievance and requested information from the city and county of San Francisco. They asked for the names, the contact information, and race and gender data for each employee who had been released from probation or had their probation extended for going back to 2016. The union needed this information in order to identify a potential grievance, in order for them to be included in the class action, to see if they were interested in being included in the class action, and also to evaluate the merits of the case to see whether or not the extension of probation or the release from probation was for legitimate reasons or was likely because of discrimination. The city agreed to provide the list of employees and ultimately agreed to provide their personal contact information, but refused to provide the individual racial and gender information, claiming that it violated the privacy rights of employees. So the union filed a PERB charge. It went to a hearing before an administrative law judge. and the administrative law judge ruled that the union had a right to the information. The City and County of San Francisco appealed that decision to the Public Employment Relations Board in Sacramento, and PERB agreed with the ALJ that the union has the right to the information. And there's two key components to this decision that merit being discussed. First, PERB ruled that a union has a legitimate purpose in challenging discrimination and harassment in the workplace. And the union is allowed to seek information in order to further that purpose, right? So the union has a right to protect its members from discrimination and harassment, and they have a right to the information they need to protect their members. Second, the confidentiality interest that the city raised was considered to be weak by PERB, especially in contrast to the union's strong need for the information in order to prevent discrimination in the workplace. Now, the City and County of San Francisco never denied that the union's request for the information was legitimate, or that the information that the union asked for was actually needed. The city conceded that the union had a legitimate purpose in seeking it, but nonetheless refused given the confidentiality interest. PERB said that that's not how it's going to work, and that when the union has such a legitimate need for this information, the confidentiality interest is weak and does not justify withholding the information. Because this is a PERB decision, it is binding on all public employers in the state. So now this request for information for individual demographic and gender information is a powerful tool that unions can rely on in order to challenge and root out discrimination and harassment in the workplace, especially through a class action grievance challenging that certain conduct of an employer violates either civil rights laws or an anti-discrimination provision of a collective bargaining agreement. If you have reason to believe that there is discrimination and harassment in your workplace, talk to your union, and unions, please consult your labor counsel for advice in these types of situations.